Hello, everyone. My name is Brendan Corbalis. I am the Assistant Director of Victim Services at SeniorLAW Center. I also am a staff attorney and handle a caseload out of Bucks County. And with me is my colleague, Pilar Diaz, who is a staff attorney out of our Philadelphia office. And we'd like to thank Plan and Kelly for inviting us and allowing us to be here today. All right, the subject of this CLE is twofold. One will be a quiet title, and the other will be about ejectment. But before we get started, I wanted to tell you a little bit about who we are and what we do, and make sure that everybody can hear me okay, because I know sometimes the audio is this okay? Can you hear me good? Okay, great. So SeniorLAW Center, who are we? What do? We protect the rights of older Pennsylvanians. This is our vision of the world, and this is what we do. We have our main office in Philadelphia, where we've been providing direct legal services for about 40 years. And recently, within the past 2 to 3 years, under a Victim of Crime Act fund, the VOCA fund, we've been opened 4 offices in the outer counties, so Bucks, Delaware, Chester, and Montgomery. And we provide services there as well. The dogs, okay, let's see. We are the largest provider solely devoted to Pennsylvanians, older Pennsylvanians, and we're an independent nonprofit organization founded past 1978. So we have been serving about 5,000 seniors every year. We also have a helpline that we run throughout the state. Again, direct individual representation. We provide information, referral services, legal education, professional training, and systemic advocacy locally, regionally, and nationally. We have legal staff. We also have a pro bono panel. And we do focus on those in the greatest economic and social need. Although in our victim service program, which both Pilar and I are team members of, income is not required. So you don't have to have a low income in order to receive our services. You just have to be a victim of a crime. So that's a little bit about who we are and what we do. We do have also interpretation services to assist clients who may have limited English proficiency, and we can provide those services in over 150 languages. So a bit about older Pennsylvanians and why it's important. You can read the stats here. 1 in 4 Pennsylvanians are seniors today, and it's estimated that in the United States, by 2035, there'll be 78 million people 65 years or older. So it's a growing population. Here's the global trend. So I think that a lot of people think of elder law or older Pennsylvanians, older Americans as sort of a small group, and it's actually becoming a much larger group. So we hope that this is useful for everybody, regardless of your practice. Even if you're not focused on serving older clients, you're going to have older clients. And these are 2 situations that we find come up a lot, and we're going to talk about those. So these are the situations that involve the abuse and some 2 possible remedies that may not always come to mind. And with that, I'm going to turn it over to my colleague, Pilar, who will talk about quiet title. Thank you.
Hi, everyone. My name is Pilar Diaz. I'm a staff attorney with SeniorLAW Center. Can everyone hear me okay? Brendan, can you hear me okay? Okay.
Your audio is good.
Okay. So I'm going to talk to you today about quiet title based on fraudulent conveyances. I will not be discussing adverse possession. So as Brendan said, we're with Victim Services. We are funded by the Victims of Crime Act. So here the crime would be fraudulent conveyances. So I apologize. I meant to share a story in the chat before we got started. So let me do that now. So I'm going to be referring to these on and off during my presentation. So I hope, oh, I think it's too long to paste. Oh no. All right, well, I'll just read it. Brendan, do you mind just sharing Jane's story? Okay. So Miss Miller lives in a home owned by her late mother, who's been deceased about 10 years. Probate file for her mother, Rose Miller, was never opened. About a year and a half ago, Jane had some renovations done. She moved out of the home for about 2 weeks. Shortly thereafter, she received a notice from the recorder of deeds that her home was transferred to Terry Miller for $1. Jane went to the recorder of deeds office and obtained a copy of the deed. The person claimed they were Rose's daughter. Jane did not bring a copy of the deed or the alleged fraudulent deed with her. Jane had a property tax agreement with the city in which her property taxes were reduced to her age and fixed income. She's now overdue on taxes and unable to receive a payment agreement because the home is on her name. So this is a pretty typical case that we get in Philadelphia. Fraudulent conveyances are so common that we actually have a task force in Philadelphia between us and all the legal aid communities to discuss what's going on. There are a lot of abandoned houses in Philadelphia, and a lot of our clients have home in disrepair. It's not surprising to have a client call in because their water's been shut off for ages and they're trying to figure out how to turn it back on because they can't afford to replace a pipe or one thing or another. So it's also pretty common for people not to probate their homes and live in a home that maybe was owned by a generation or two ago. People don't always know that they need to probate their homes or they can't afford it. Letters of administration or letters to testamentary tend to be expensive. So it's a pretty typical case that would come in. Usually I have to start with checking the deed, asking for death certificates, and I'd probably take this for investigation before, so I can look at the probate file before we'd agree to represent. I know within legal aid community, it might work differently. You guys might agree to represent right away, but you know, we do our intakes through our legal advocates, and then the attorney would meet with the client and give some advice, and then it goes to a supervisor to decide whether to represent or not. So we're gonna move on to Beth's story. So Beth obtained her home in her name after divorce. Beth is in her late 70s, is hard of hearing, has mobility and other significant health issues. John Smith calls Senior Law Center on Beth's behalf. He apparently is her landlord. John tells the intake worker that a woman named Nella moved to Beth's street, befriended her. Nella then arranged to become Beth's paid caregiver. According to John, at some point, Nella told Beth the house was being condemned by the city and they were going to sell it. Beth was having problems affording the home and she agreed to sell the home for $8,000. Nella then took Beth to a hotel and basically left her there. John picked her up on the request of one of Beth's friends. John is now renting to Beth. Beth is very dependent on John. The intake number for Beth is John's number. So it's actually not uncommon to see kind of stranger danger cases. People see seniors living by themselves in a community and will befriend them and try to basically take advantage of them. Having a member of the community basically become that person's caretaker, it's not uncommon, and they do it to kind of win their trust. Eventually, they rely on this person so much that they'll just believe them without independently verifying something like, your home is being condemned and you need to sell it to me or you're going to lose it. So I come to the other point. A lot of people will believe that because she signed this deed that the home is not fraudulently conveyed, especially the police, if this was to be reported. That's not the case. Obviously, she was relying on some false information told to her by Nella. And that's what really makes the fraudulent conveyance here. We're going to talk about void versus voidable cases later on, but that really is what makes it a fraudulent conveyance. She would have not sold this home if not this information had not been given to her. So moving on to the second paragraph in terms of third parties. It is very, very common for elderly clients to have someone accompany them to the office. Maybe they don't feel comfortable going to the office alone. They need someone to kind of support them and help advocate for them in the process. Or sometimes it's a bad actor who, you know, wants to know what's going on in the case because they're the ones exploiting your client. So you need to be very, very careful with letting people in when you're interviewing with the client. Always talk to the client alone, because you want the client to make their own decisions and feel empowered to be able to tell you the goals of representation, right? So if there's someone else in the room, they might be influenced by that other person. So always talk to the client alone. In this particular case, I went to the client's home. She was hard of hearing, but she did lip read pretty well, and I spoke pretty loudly as well. Obviously, with COVID going on, we're not doing any home visits. Senior Law Center is working from home, so that does make it a little more difficult. But we're always trying to look for creative solutions to meet our clients' needs. Brendan, you can. All right, so before filing, you know, always do the legwork. Here in Philly, we have Philodocs, so we can look up deeds online. If you can't do that, you know, go to the Recorder of Deeds. Always obtain a certified copy of the deed. I always file a certified copy with the complaint because it is self-authenticating. It speaks for itself. Review a title report. They may be other liens on the property you don't know about. In Jane's case, you know, she had outstanding delinquent taxes. It's not uncommon for people to have a decree entered against the property and they don't know because the property wasn't in their name, and then it gets served. So, you know, try to get a title report if you can, or see if you can look up if there's delinquent taxes, any water liens, anything like that, because, you know, the goal is to get clear title. There's other liens on the property, you know, there needs to be an assessment about whether or not realistically you can get clear title after this case is concluded. So I have a case where the bad actor was kind of like Beth's case, where someone that befriended my client in the community ended up doing this to other people. She had about 7 other deeds under her alias name, and she had some deeds in her name and an accomplice's name. And she had been doing this again to other people and buying properties for very, very low value. We ended up being able to make a police report and pointing the detectives in that direction. It's always worth looking at. You know, you can't solicit clients and let them know that their houses have been transferred to this bad person, but the police can make an investigation, right? So it's always worth reporting it to the police. As I said, doing the legwork, certified copies of death certificates, looking at the probate file, trying to figure out if there's other heirs on the property. We don't represent in contested probate matters, but you know, if there are other heirs, you want to figure that out, and reach out to the notary. You'd be surprised. Sometimes the notary is willing to cooperate. I think there's a tendency to assume that the notary is in on it too, but for the most part, I've gotten good feedback from notaries. Notaries will report this to the police and also to the Department of State that oversees their notary certification or license. A lot of people's first instinct is to assume that the notary's in on it and also sue them. Notaries aren't bonded for very much, and keep in mind this is equitable relief. So you may not be looking for a money judgment. For the most part, we don't take on cases where there is a money judgment involved. We make very few exceptions for that, so just keep that in mind. Brendan, next slide. So I did mention void versus voidable. So Jane's case would be void ab initio, basically just void. So in Jane's case, if Terry, the bad actor, and I apologize, I meant to have this in the chat so you could refer to it too. Terry, the bad actor, who is the new fraudulent owner of this house, if she were to get a mortgage on this house, which has happened, or if she were to try to sell the house to a subsequent purchaser, a third party, that would be void. Assuming you win your case, all the subsequent conveyances or interest in title could be voided. You would have to join them as defendants, particularly mortgages. But the good thing is that it's void. Voidable cases would be more like best case. So in best case, Nella, her caregiver, asked her to sign that deed. Nella, in real life, it is a real case, flipped the home and actually tried to sell the home for like 5 times what it was like worth beforehand. Luckily, she didn't sell the home. This was a criminal case before we took it. But had she sold the home, our client would unfortunately would have a hard time trying to get back that home as to that subsequent purchaser, that innocent third person that would have bought the home. And if they got any mortgages, the mortgages could possibly be enforceable as well. So that's something to consider. Certainly you want to consider other causes of actions that can get you money damage, and we'll talk about that later. But it's something to think about when you get a case like this. Next slide. All right, so I'm just going to give you a quick overview of the case, how a case would proceed from beginning to end, just so you get an idea. So, as I said, you do your legwork, get the certified copies of things, the title report to review any other liens on the property. We're going to talk about filing a complaint and what a lis pendens is in a minute. But once you get to service, as I said, people might be using an alias. So you want to consider whether you want to file a motion for alternative service and have the complaint posted on the property of service. That's something we ask for pretty commonly. The judgment would obviously be asking for the house back. And if that were granted in your favor, you would prepare a deed of confirmation. And I did put that statute in there. The transfer taxes would be waived, but it is a deed of confirmation since the other deed was void and fraudulent from inception. And then you would record that deed of confirmation so that you can mark that your client now has title to the property. So next slide. All right. So filing a complaint. So the first line on your complaint should always be a property description. So you're gonna, say this is a action for real estate concerning so address, have your property description. It's gonna say situated. If you look at the deed, it says situated or located at, and then it's gonna have like coordinates or describe distances between certain streets. So that's gonna be your property description. Obviously, the jurisdiction for real property disputes is in situs, always where the county where the property is located. Surprisingly, there's no statute of limitations for fraudulent conveyances. Keene versus Foreman is the Pennsylvania Superior Court case, where the Pennsylvania court stated that the 21-year statute actually applied to possessory interest and not interest clouding title. And so this was actually a mortgage dispute where a mortgage was fraudulently conveyed by one of the partners because the property was owned by a company. So include a lis pendens. Lis pendens basically records a dispute in the chain of title, and we'll go into that in a minute. But see your local rules, because Philadelphia doesn't require a verification with the lis pendens. I know Berks County does. So just see your local rules. I mean, there's a lot of people using list pendants inappropriately, so some counties have modified that just to kind of make sure and verify that, you know, these list pendants aren't being inappropriately used, and we'll get into that in a minute. So wherefore clause. So I'm citing a statute here. I was going to include a sample, but the statute's probably better. So you are allowed to direct the recorder of deeds to record a deed of confirmation. You don't have to have the other party prepare a deed for you. And, you know, there's a couple things that your wherefore clause should say. Obviously, you want to prevent them from asserting any right. You want this declared void. If there's any mortgages, they have to be declared void. Obviously, you don't want to pay property taxes or transfer taxes, excuse me, on this when you file your deed. And if you can, try to say, you know, no recording fees either. Whether or not the recorder's office will honor that is a different question. But I would try it anyway, just to save your client a couple bucks if you don't have a litigation fund. All right, next slide. All right, so always prepare a list pendants with the complaint. So there's two different types. First, you record it with the court with the press speed index, and the second is first to record. You would actually file that at the recorder of deeds. So what a list pendants does, as I said, it records a dispute in the chain of title. So it makes it really, really hard when you're running a title report. If you're trying to buy that property as a subsequent purchaser, it makes it really hard to get a mortgage because realistically, the mortgage company is going to know that you can't insure that property since there's a dispute, and you might be taking the property subject to the dispute. So it won't prevent a sale of property or a transfer, but it can be really hard, and it puts the subsequent purchasers on notice. Next slide. All right, so what other claims would you add to a quiet title complaint? So we did talk about this earlier with voidable. Oh, Brendan, go back one slide. Thank you. With voidable deeds, so you do want to consider adding other causes of action, you know, just in case they're found to be liable in that mortgage or a third party, a subsequent purchaser. So adding additional claims for fraud, unjust enrichment, misrepresentation, undue influence can be a little tricky because you have to show a confidential relationship, but it is possible. There is some case law that allows you to prove certain elements if you're trying to prove undue influence between family members. So don't discount it. With Beth's case, as I referred to earlier, that was a case where we added conversion because there was cancer medication that was stolen that was worth like thousands of dollars. So we added that on so that because it is avoidable action, if she were to lose the quiet title matter, maybe perhaps she would be able to at least get some money out of it so she can live on, because she did after all lose her home. So that's all for quiet title. I'll let Brendan take over.
And actually, I'm sorry, this is Kelly, and I'm going to launch the first of the CLE poll boxes. Attorneys, you will have 1.5 minutes to respond to this one. Thank you. And Brendan, please feel free to continue.
Thank you, Kelly. And thanks, Pilar. We're going to see if there are any questions at the end of the next section. So thank you. I don't have the chat box up here, so if someone's looking at that, let me know. Okay, so the next action we wanted to talk about is ejectment. Some of you may be very familiar with this, maybe some not so familiar. It's a very basic overview on how it can be used to protect older clients who may be suffering at the hands of an abuser or undergoing some sort of financial exploitation. So what is it? It's a civil action to recover land, basically. So a common law was used to expel a defendant from a parcel of land, and the reasoning is, the argument is that the plaintiff has superior title. Here you have a nice definition from the Superior Court. So jurisdiction, this is an interesting case. It would, if you deal with landlord-tenant matters at all, or ejectment, this is a very important case. You're probably aware of it. Last year, Asseline versus Reynolds. And it really addresses the issue of jurisdiction. In this particular case, what had happened is the folks who wouldn't leave the property were the previous owners, and the home had foreclosed, and the sheriff was taking it to sale. And so now the new owners were suing the previous owners, and this happens, is quite common in these kinds of actions. And they sued the magisterial district court. And basically the case went up, and what the Superior Court and then the Supreme Court affirmed is that without a landlord-tenant relationship, you cannot sue under the Landlord-Tenant Act. So in Philadelphia, for example, we have municipal court, and in the counties, we have our magisterial district courts, and they are the proper venues for a landlord-tenant action. But in this case, the parties did not have a landlord-tenant relationship. And so the proper action was ejectment, and that has to be filed in the Court of Common Pleas. Here's your statute that you want to be familiar with, and of course, there may be other statutes that might apply to your situation. So the general procedure in filing an ejectment. First, of course, is a notice to vacate to the defendants. It's recommended. Usually it's 10 to 15 days. If the folks have been there longer, for a longer period of time, a couple of years, you may want to say 30 days. Then you'll file a complaint. Service we'll talk about in a moment, but under Rule 410, which deals with any kind of land or property issues, there has to be personal service. Then you're going to ask for the judgment for possession, the motion, the writ, which goes to the sheriff, and then the sheriff, of course, will effect the removal of the folks who are there that aren't supposed to be there. Here's the rules of civil procedure that govern these actions, and also the local courts, of course, have their own rules, and you have to always check those. Some of them are very interesting twists to them. So the notice to vacate, not recommended, but it is recommended, not required, but it's a best practice. Basically, you're saying in this notice, you have no right to be in the property, right? So it's not as though you're saying your lease is up and we're not renewing it. We're saying you have no right. If there was permission ever given at any particular time, that permission has now been rescinded, and you have to leave. So sometimes you have squatters, right? That happens particularly in the urban areas. You don't know who they are. You don't have identification. You just know that someone's on the property and they're not supposed to be there. One of the things that you can do is have your client register for USPS informed delivery. If you don't know what that is, you can do a quick Google search. It's an interesting service, but the client has to apply for it. And basically they'll receive an email. They'll provide an email address, and they will receive an email of what mail is being sent to that property, in which case you may very well discover the names of the people who are living there if they're having mail delivered. You can also send it to, address the letter to unknown occupants of 123 Main Street or whatever it may be. But it's important that the notice clearly says that you have no permission to be here and you must leave. So if the defendant does not leave by whatever that date may be, you're going to file a complaint. And again, it has to be accompanied by a certified copy of the deed, not just a copy, but a certified copy. Usually requires an in-person visit to the recorder of deeds, but depending on your county, it may not. And again, we talked about service, so to Rule 410, here's the rule. I'm not going to read through it, but I think the important thing to remember is that you have to have personal service. If your client is in the household with the undesired parties, it's important to tell your client not to accept service, right? Because that's not going to work out. So the other folks have to accept it, but it doesn't have to be the named defendant. It can be anyone else, a competent adult who's living in the home, okay? So you're gonna wait your 20 days, and then what happens? So if this happens, what we have come across for the most part, and what is most likely to happen, is a default judgment, because there are very few defenses to ejectment, and the defenses are very narrow. So these are the defenses really. There's a 21-year statute of limitations, right? The defendant has an interest in title, which is they're filing sort of a counterclaim in quiet title, right? Where they have an interest in possession, and whatever that might be, they would have to allege that there's a landlord-tenant relationship, but you've done your homework, and so you've brought this action in ejectment because there isn't one. So often that will be the sort of common response is, well, they said, you know, the owner said we could stay here and we've given him $50 a month, or we're working for food or whatever. They're very sympathetic stories often because these people have been living there, but it's not a defense. So you're going to follow up with the motion for writ of possession. You're going to include a member. I think I skipped the slide. No, that's it. Yeah, you're going to. If you go to court, you can make an oral motion for possession, but you want to follow up with a written motion and include a memorandum in support of that. So after it's granted, which most of them will be, you're going to file a precipice for writ of possession, the Office of Judicial Records, go to the sheriff. So this part's very similar to what it would look like in an eviction matter. But again, we're talking about ejectment. So this is the story that I was going to share with you folks today. This is a real story about a real client. It touches on a lot of the things that Pilar talked about. I would, Patrick and his longtime partner, they lived in a home for many decades. And when his partner died, he continued to live in the home independently and, you know, quite well for a long time. But as the years went by, he, as often happens, he sort of needed some help to do things around the house. He needed some grocery shopping done, that kind of thing, some of the daily activities of living. And as Pilar mentioned, unfortunately, there are predators in the community who look for older clients or older Pennsylvanians or older members of the community who have some sort of vulnerability and some sort of property. And they will often target it. There are good people in the world who do very good things out of the kindness of their hearts, but unfortunately, in our line of work, we also see a lot of people who are very calculated and in their plans to deceive and exploit older folks. So he befriended a younger couple that was in the neighborhood. He was introduced to them through some other neighbors. They were very nice. They offered to help him out. And they said, oh, we can do grocery shopping. We can run errands for you. We can do some home repairs if you need any. So that all sounded great to Patrick. And he said that would be great. So I think no surprise that after a while, you know, they were living there. And as time progressed, Patrick became dependent upon them, right? Not just for assistance, but for companionship. And I think this is important, particularly in the context of victim services, although it may not be a straight up legal point. Abuse takes many forms, and psychological or emotional abuse is very real, and people can become very dependent on people who are abusing them. This is a dynamic that's well documented, and we see it a lot. So what's happening now is Patrick's world is becoming smaller, and these two young people, this couple, are becoming his world. And so they're now in charge of his life and living in his home. So naturally, it doesn't happen all at once, but abuse starts. And it's little things, unkind words, you know, they're not so willing to help out, the dynamic changes. And this happened about 2 or 3 years before Patrick actually came to us. You know, there was a slap and then there was a push, and that's how it started. When Patrick contacted us, he had actually been in a nursing home for several months because he had fallen down the stairs. This was before the pandemic. We went to the nursing home to visit with him, and after several visits and speaking with him and agreeing to help him out and gaining some confidence in him, he confirmed what I had pretty much thought, which was that there wasn't an accidental fault on the stairs. And I think the people in the nursing home knew it too, but he would not, he wouldn't tell anybody else. He told me, but he wouldn't say anything to anybody else. So he was preparing to go home, and they were prepared to discharge him. But as you know, there's a safety plan that has to happen, or if you don't know, there's a safety plan that happens as part of a discharge from a medical facility or nursing home. And he had a home to go to. There were some modifications that needed to be made in the home. That was not a problem, and he was ready to go home. But as you can imagine, the problem was that the couple was still there. And he couldn't evict them, right? Because they're not landlord tenants. They don't have that relationship. And at that point, he couldn't file a PFA because the incidents of abuse had occurred far enough in the past, and he wouldn't allege the incident of abuse with the pushing down the stairs. And he was very reluctant to do that. Additionally, as you may or may not know with the PFA statute, there are some standing requirements. They weren't related by blood or marriage, and they're not actually living in the same household now, right? They are living in his home, but he's living in the nursing home. So the PFA wasn't really an option. So that's where the ejectment came in. Because they've lived there for several years. We weren't talking about adverse possession at that point, and you may also know that that changed to 10 years from the 21 years in certain cases. That's a recent change in the law. So we filed the action for ejectment, and we sent the notice to vacate. And although we're not required to do this, we sent it by first class, but also by certified registered mail. And actually, to our surprise, both of the parties, because we named them individually in the suit, both signed for service, so confirmed that they had received the notice to vacate. So we were waiting the 20-day period, for an answer, and we were going to move forward. I'll mention that at this time, I learned that the local police were involved because there had been a lot of complaints about this couple, and they were doing things like hooking up electricity to another neighbor's house because they had not paid the bills that they had supposed to have paid, that were supposed to have paid for Patrick, so the utilities were shut off. So this didn't bode well. So this is not an uplifting story, but I think it's important to share, because one of the things that we look to do at Senior Law Center is not to win cases per se, but to provide a voice for folks who may not have one, or more importantly, to help them have their voice heard. And so the outcome for Patrick was not good. Most ejectment cases are, but this was not, because both parties vacated. The problem was that in vacating, they also destroyed the home. And they had done a lot of the destruction before that they actually left. And I mean, they stripped the home of everything: wood, carpets, piping, anything you can think of, ductwork. And it was actually condemned by the county. So it wasn't a successful outcome in that sense. We couldn't go forward with the ejectment. They were gone. We cut them out, which is what we said we would do. But obviously, it's not the outcome that any of us wanted. What I can say about Patrick's story is that he is a victim, and he was a victim of financial exploitation and of physical and emotional, psychological abuse, verbal abuse. And he'd become really dependent upon these folks. And he had no one left. He had no family. He had no friends. And this couple were the only folks that he really had to turn to. And they were basically killing him slowly. And he was able, I think for the first time, to have somebody listen and take him seriously. And so we advocated for him. And eventually he did have to sell the home, but it was a situation where, had we not been involved, or had he not had the wherewithal to stand up and ask for help, the house would have been lost anyway, and there would have been a much greater loss. So we often define our success at Senior Law Center, not in terms of damages or outcomes, but have we provided a forum for justice? Have we helped somebody access the court system who might not have otherwise been able to? And have we allowed them to raise their voice to be heard, regardless of what answer comes back? So that's ejectment in a nutshell, but it's ejectment in terms of elder abuse and financial exploitation. That this is a common scenario we see many times. The bad actors, if you will, are adult children who believe that they have a right to be in the home. They believe it's their inheritance. When I say adult children, I mean sometimes adult children who are in their 60s and 70s, who are living in the homes of parents who are in their 90s. And this is something that I've come across quite a bit. So it's an interesting way to look at abuse, because it's not the first thing that you might think of. But sometimes you just have to get the person away from the abuser. And this may be a way to do it. And also, if the ejectment, is a way for that person to begin to reclaim and heal, right? To sort of get their dignity back. And that's what we do with ejectment at Senior Law Center. So I think we'll open it up for questions. I don't see the chat box, but maybe you can see it, Pilar or Kelly.
So yeah, Brendan, I just want to answer a couple of questions from the chat box. I kind of already did. So we typically bring claims as plaintiffs in ejectment matters, sometimes even in landlord-tenant matters, where the person was paying rent to our client and they're not related, so we can't file PFA. I do understand that some of you, or a lot of you, might defend ejectment actions. So, I mean, while I haven't seen these type of case in municipal court, or magistrate court, it's because I don't typically defend landlord-tenant cases. So a lot of people do get some false information and try to take these cases under eviction and landlord-tenant court because they think eviction is kicking someone out of their home. They don't realize it's specific to the Landlord-Tenant Act. What they're really looking for is an ejectment. So that's really why they're filed so much. And I can't pronounce the case name. Is it versus Reynolds? We're just going to go over that. That's why the magistrate would have seen so much of those cases. Do we have any other questions?
I don't see the chat box on my screen, sorry.
Brendan, hi, this is Michelle Cohen.
Hi, Michelle Cohen.
Here's another way if you really need to get an abuser out. The new, there's a new squatter law, and I was able to get out an abusive partner that was not a romantic interest. I was able to get them out under the squatter law, even though we as public interest attorneys are not crazy about the squatter law. It worked for me in this case.
Yeah, so thank you, Michelle. So that's Philadelphia specific. That was brought by a councilwoman in Philadelphia. So we had some squatter rights advocacy to prevent bad landlords who don't have rental licenses, because those are required in Philadelphia, from kicking people out of the home. So as a response to that, they did make emergency ejectments because there were squatters taking over abandoned properties and making their home there. In some of our clients' cases, they'd leave to visit kids or go away for the weekend. We actually had a case where, our client left for the weekend and he came back and there was people living in his property, and they were smart enough to tell the police that they were renting from them. And so the police actually didn't help kick them out. So then we had to move up to that next step with the emergency ejectment. So thank you, Michelle.
Well, Brendan, I think you're muted.
I see there's a question. Thank you. Have you ever seen an ejectment claim brought in magisterial district court as opposed to the common pleas or municipal court? Well, municipal court and the magisterial district courts would be the same. Philadelphia is under home rule charter. I believe Pittsburgh is as well. So they have municipal courts, and in the other counties we have the magisterial district court. No, but I can tell you, I once tried to file a landlord-tenant claim in MJD without a lease. And this was not in Philadelphia. Filed many of those in Philadelphia without leases, or a lease is fine. And this particular district court would not accept it. was not an action in ejectment. It was a Landlord-Tenant Act action, but they said, oh, that's actually the, ejection, not ejectment. They said ejection, and you have to go to common pleas court. So I don't know if that answers your question. I hope so. The other question, the plaintiff's bar panel at a CLE once suggested the trick in ejectment is to avert that there's no landlord-tenant relationship. On that, yeah. And if the defendant, go ahead, Pilar.
So that is actually required in Philadelphia. You have to plead that there is no landlord-tenant relationship before you can even file an ejectment, because it's such a common defense. So check with your county. I mean, it is a good idea to plead that in the ejectment pleading, just so that, you have it out there. But it is required specifically in Philadelphia. And then I apologize, Brendan, another thing I didn't mention. So with the CDC, the administrative order that halts evictions because it declared a public health emergency, I believe. So in Philadelphia, you are actually required to fill out an affidavit saying that you're not a landlord before you file an ejectment now. So check with your counties to see what they're doing before you file one, or if you're defending an ejectment, see if maybe they'll allow the CDC order to apply if your county is recognizing that. It might help your clients.
Mm-hmm. Someone's asking about Patrick and about homeowners insurance and filing a VCAP claim. And we did look into both of those, and there were criminal charges that are, well, they're pending. The young couple has disappeared, so and law enforcement's not hot on their trail. Not a big case for them. So, but yes, we are looking into that, and we helped him with that. Okay.
While we wait to see if there's any other questions, this is Kelly, and I'm going to launch the second of the CLE poll boxes. Attorneys, please respond for CLE credit for your participation. Thank you.
And did you want to, Pilar, did you want to go a little further into the change in the adverse possession statute of limitations?
Yeah, so I know I didn't talk about adverse possession in regards to fraudulent conveyances because I wasn't covering that, but it is a defense to ejectment, and Pennsylvania did change the law. I think it was June 2019. So the statute of limitations for real property actions is still 21 years, but they lowered it for adverse possession to 10 years. So if you've been occupying a property for 10 years, I think you have to still wait another year before you can actually file for adverse possession, but basically that statute is run after 10 years.
Yeah, and I think there's some carve-outs with if it's owned by a corporation or things like that in that particular. Yeah. Okay. Anybody else have any questions? We were concerned it was going to be too long. Let's see. Okay.
Doesn't look like we have any others.
Anybody want to share something? It doesn't have to be a question. Anyone want to share a story or some wisdom that they've accrued by dealing with one of these actions?
Okay, well, thank you, Brendan and Pilar, for joining us and for your time and sharing this information with us. Thanks to everyone who attended the session today. And again, it was being recorded, it is being recorded, and will be available on the Plan YouTube channel. If you want to refer any other colleagues to watch it to get the information. So everyone have a great rest of the day and take care. Thank you.